previous edition, we explained what financial planning is, which is the process of employing strategies to help you achieve your personal goals. In this edition, we dive down into your estate plan. Two key aspects of your estate plan concerns, firstly, the ownership of the assets, and then secondly, the transfer mechanism, or how the assets are transferred to those you wish to benefit when you no longer need them. Now, estate planning in a nutshell is the process of planning to ensure that the right assets are passed to the right people at the right time, with the taxman or the tax office getting as little as possible. Asset ownership is the first thing to consider, as I said, and one thing that many people aren't aware of is that you can only address individually owned assets in your will. Jointly held assets are automatically passed on to the other owner on the death of one party. However, even that it can vary between whether it's owned jointly or tenants in common. Tenants in common is really where you have a set percentage, so that say I own a house jointly, tenants in common with my wife, I might have 50%, she might have 50%. If I own it jointly, it's 100% hers on death, on my death. But if it's tenants in common, then my half I can leave to, say, my children in a will, and she has her 50%. But jointly is most common. The other aspect of ownership is, do you own assets, well, do you perceive you own assets which are actually owned in a trust? And that could be super or other types of trust. If that is the case, it's likely you are the beneficial owner. In other words, it's for your benefit. But you're not the legal owner, and often it's the trustee who's holding the assets, holding the legal title of the assets on your behalf. And those cannot be addressed in your will because they're not yours. And so it's important to put in place a mechanism to direct what should happen to those if you regard them as yours and you want to transfer the control of those to other people on your death. And companies, of course, is another one where a company is what's known as a legal entity, has a single legal personality, so that if you die and you're the sole director of a company, the company will still carry on after your death. And control of that company rests in the shares. So if you do have a company, you need to make sure that the control through your shares is passed to the personal people that you want to have that control after you no longer can. The second aspect of your estate plan, after you've considered the asset ownership, is the transfer mechanism. So how do you get the asset ownership transferred? Now, the will is a legal document that specifies how to transfer the assets that you own. And often linked with that is what's known as a power of attorney and guardianship. An enduring power of attorney is one that endures through your mental incapacity. In other words, if you get knocked on the head and you're unable to make sound financial decisions, an enduring power of attorney would be able to make decisions on your behalf. Similar to that, enduring guardian is giving somebody you trust the ability to make medical and lifestyle decisions on your behalf, such as how you want to be treated medically, how much morphine you want, or whether you want the life support machine kept on or not, or even where you want to live. When you get to the stage of life where you might have advanced dementia, you might want your partner or somebody else you trust to actually make those decisions for you, rather than leaving it to a tribunal of lawyers. For those that are involved in a business, in partnership with others or through a unit trust or similar structure, it's very important to have a buy-sell agreement that clearly specifies, with the minimal tax consequences, of what happens to your ownership interest in the event that you die or become unable to contribute to that entity anymore. And those can be both funded, typically through insurance, or unfunded, which would simply express what happens when, and could actually be involve something like a vendor finance, when the other people who are buying under the buy-sell agreement will pay over a specified period of time at a particular rate. Now, a testamentary trust is something that allows you to leave assets to people with a bit more protection than leaving them outright. So If you have, say, adult children who are involved in a business and you think that business could go a bit awry and be prone to creditors, it could be prudent to leave the asset to them through a testamentary trust, which is a trust set up and established through your will, rather than leaving to them outright, because that would be protected, or a much higher degree of protection from creditors than just giving them outright. Also, if you leave money to children under 18, could be grandchildren or any children really, if it's through testamentary trust, they'll be taxed as adults on the income generated by those assets, whereas if you left it to them outright, they would be taxed at penal rates because they're under the age of 18. So testamentary trust can be useful for both protection and tax reasons. Thank you for watching.